This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author, and producer of this and these videos. Today I'd like to talk about property insurance fraud, starting, of course, with the most prolific of property insurance fraud on arson-for-profit. Arson is the intentional burning of property. It no longer is limited to specific types of property, although perhaps the most dangerous of all methods of insurance fraud. People continue to attempt insurance fraud by burning their homes, vehicles, and business structures. The FBI has advised that in 2010, for example, 15,475 law enforcement agencies provided 1 to 12 months of arson data and reported 56,825 arsons. Of the participating agencies, 14,747 provided expanded offense data regarding 48,619 arsons. Arsons involving structures, that is, residential, storage, public, etc., accounted for 45.5% of the total number of arson offenses. Mobile property was involved in 26% of arsons, and other types of property such as crops, timber, fences, etc. accounted for 28.5% of reported arsons. The average dollar loss due to arson was $17,612. It's probably this small because most arson fires are trash fires, dumpster fires. Arsons of industrial manufacturing structures resulted in the highest average dollar losses, an average of $133,717 per arson. Arson offenses decreased 7.6% in 2010 when compared with arson data reported in 2009. Nationwide, there were 19.6 arson offenses for every 100,000 inhabitants. By use of technical devices, chemical analysis, and even trained dogs, it has become more difficult for the arsonist to cause a fire that appears to a trained investigator to be accidental. Arson is not excluded in any first-party fire insurance policy. It is, in fact, a specifically covered peril, fire. There is no arson defense available to an insurer. The defense for an arson caused by an insured to defraud an insurer is misrepresentation, concealment, or fraud. If an insured sets fire to his furniture or car to defraud the insurer, the defense available to the insurer is fraud, not arson. To defend a claim based upon fraud by arson, the insurer must prove the following. 1. The property was insured under a contract of insurance. 2. The contract of insurance contained a provision allowing the insurer to void insurance because of misrepresentation, concealment, false swearing, fraud, or an exclusion for intentional acts of the insured similar to that in the New York Standard Fire Insurance Policy. The insurer must also prove the fire was not accidental, that the fire was caused by the acts of a person or persons, that the fire was set by the insured or someone acting for the insured, and that the fire was set for the purpose of defrauding the insurer. Under Michigan law, for example, In order to establish an arson defense, the insurer need only show that the fire was of incendiary origin and the insured had both motive and opportunity to set it. Each element may be established by circumstantial evidence because there is rarely direct evidence that a fire was set by an insured. Without an eyewitness or other direct evidence, the insurer can prove the insured was involved in an arson-for-profit circumstantially by presenting evidence of the insured's motive, opportunity, and ability to cause the fire. Motive is not required to prove arson, although showing a trier of fact a motive makes it easier for the trier of fact to believe the insured caused the fire to occur to defraud the insurer. During the Rodney King riots in Los Angeles, there were many fires set by the rioters. One grocery owner set fire to his grocery and was brilliant enough to do so on video maintained by his own security cameras. He was arrested and charged with arson and arson-for-profit, but claimed that he set the fire as a signal to the police to protect him from the rioters. Much to the surprise of everyone, and especially his insurer, he was acquitted because the jury believed that he was in fact innocently setting the fire to protect himself. Regardless of an unusual decision by a jury with regard to a riot, if opportunity and motive combine and all accidental causes are eliminated, fraud by arson or arson-for-profit can be proved. In Fitzgerald versus Great Central Insurance Company, a 1988 decision of the Sixth Circuit, following a fire, plaintiff's claim for benefits was denied. The insurers claimed that Gerald Fitzgerald set or procured the setting of the fire. Plaintiffs then filed a complaint against Aetna and Great Central for breach of contract. On the night of the fire, Gerald Fitzgerald, his son, and the family dog who lived in the apartment above the tavern were all absent from the building. Gerald Fitzgerald spent the night at the Coho Club in Traverse City and left his son and dog with a friend. Michael Husby, who also lived in Fitzgerald's apartment and had recently bought into the corporation, visited the bar during the evening but spent the rest of the night at his girlfriend's house. The bar closed at 10:30 that night. Nothing unusual was noted in or around the building until flames and smoke were spotted at 1:30 a.m. The doors to the bar were locked, but the separate entrance to the upstairs apartment was unlocked. There was no sign of breaking and entering. Testimony at trial regarding why the insurer denied the insurance claim met the standard for relevancy. The insurer testified that it was the insurer's belief that the insured planned to defraud the insurer from the beginning when they first acquired their homeowner's insurance policy, even though they were not living at the property. This was significant because a requirement for a valid homeowner's insurance policy is that the homeowner occupy the premises and was part of the insurer's arson-for-profit defense. In a case that I was involved in, arson occurred at a dwelling owned by an individual insured who presented a list of personal property destroyed in the fire that, if all existed in the insured's home, probably would have filled every square foot of the house. My investigator, an exceptional and professional investigator, contacted the arson investigator for the city, who provided the investigator for the insurer with 72 photographs taken while the fire was actually being extinguished. And since most amateur arsonists believe that a fire will destroy everything and no evidence will exist, they become victims of a criminal conviction. In this case, during the examination under oath, I had the insured advise the exact location of every item claimed on his list of destroyed personal property. His lawyer laughed as I did so and advised his client that I was just building up time so that I could overbill the insurance company for my time. And after I had received all of the detail, I then pulled out the 72 photographs, which showed empty closets, no furniture. Television sets that supposedly were there were not there, because of course the fire didn't destroy everything, and because the fire department was effective. The insured eventually pleaded guilty to one count of insurance fraud and was granted probation if he reimbursed the insurance company for the investigative costs. I still have on my wall his picture and the check that he issued, because if he had not paid for the insurance company's expenses, he would have gone immediately to jail. In that case, an arson-for-profit failed because of a thorough investigation by the insurance company. Other types of property insurance fraud include the staged theft, the staged water damage or mold claim, attempted insurance fraud, and other various types of property frauds like post-dating a loss. This is a fraud technique that involves a loss at a time when an individual has no insurance or inadequate insurance, and following the loss, the individual applies for insurance or increases the limits of existing coverage, so he or she has sufficient insurance to cover the loss. Failure of the insurer or its agent to see the property or obtain a current appraisal by a professional valuer of the type of property, the risk of loss of which was to be insured, especially if the insurer had included the items on its schedules before issuance of a policy, is an invitation to this type of fraud. Another type is the paper property, where the insured never had the property but had a receipt proving he had it. There was also vehicle theft fraud, which includes owner gives up, 30-day specials, export fraud, phantom vehicles, cloned vehicles, flood vehicles to avoid purchasing washed-up vehicles, and a marine vessel theft and fraud. Motorcycles even offer a tempting target for criminals that can and will result in property claims that were not owed, such as the switch, the use and insurance of used and salvaged vehicles, windshield scams that replace undamaged windshields, and charges for phantom vehicles. All of these are included in my book, Adjusting Property Claims, 3rd edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be of interest to you, please pass it on to your colleagues. It's free. And please follow me on Rumble and on YouTube and at my blog so you can be advised of future videos and future blog postings. Thank you for your attention.